Greetings everyone, welcome to the 10th Asia Pacific ADR Virtual Conference. My name is Sally O and I'm a Case Counsel at Kcab International. I may be a familiar face for those of you who joined us last year, and I'm delighted to be your host again for 2021. With COVID-19, our restrictions and unusual circumstances still continue, but in the past 2 years, we've learnt to adapt new ways. This is why we gather again virtually for this year's conference, to celebrate our ongoing and strengthened interest in alternative dispute resolution. I speak on behalf of the organisers when I say that we are grateful to see you all join us in your virtual seats. Now to begin, I would like to introduce the Honourable Pomgay Park, the Minister of Justice of the Republic of Korea. It is a great honour to have his presence with us today. Minister Park, when you're ready.
국내의 기빈 여러분 안녕하십니까? 대한민국 법무부 장관 박범계입니다. 올해로 개최 10주년을 맞은 아시아 태평양 ADR 컨퍼런스에서 인사드리게 되어 매우 기쁩니다. 우선 이번 뜻깊은 행사를 함께 준비해 주신 운시트랄 아나주뱅 불의 사무국장님과 국제상업회의소 국제중재법원 클라우디아 살로몬 원장님, 그리고 대한상사중재원 국제중재센터 우리 신희택 의장님께 깊은 감사드립니다. 컨퍼런스의 성공적 개최를 위해 많은 도움을 주신 전 세계 주요 국제중재기관들에게도 깊은 감사의 말씀을 전합니다. 시간 관계상 모든 기관들을 일일이 호명해드리지 못하는 점 양해 바랍니다. 그리고 바쁘신 가운데 행사에 참석해 주신 국제중재 분야 전문가 여러분들과 그 밖에 함께 해주시는 모든 분들도 진심으로 환영합니다. 지금 여러분께서 참석하고 계신 아시아 태평양 ADR 컨퍼런스는 대체적 분쟁 해결 분야의 명실상부한 세계적인 국제 행사로 자리매김하였습니다. 올해는 2021년 이후의 분쟁 해결 제도에 대한 전망, 끊임없는 혁신의 여정을 주제로 하여 여러 중재기관과 전문가들의 깊은 통찰과 다양한 의견을 청해 듣고자 합니다. 우선 여러 중재기관 및 실무가들이 팬데믹 상황에서 대면 중심이었던 기존 절차의 한계를 극복하고 보다 효율적이고 합리적인 분쟁 해결을 위해 어떤 노력을 해왔는지 그간의 동향과 성과를 살펴볼 예정입니다. 또한 각종 중재규칙의 개정 내용과 분쟁 해결 메커니즘의 변화 흐름을 소개함으로써 특히 이 자리에 참석하신 실무가들에게 유용한 정보를 전달해 드리고자 합니다. 부디 이번 행사를 통해 중재 실무 및 제도 개선에 대한 고민을 함께 나누면서 나아가 그 해답의 실마리도 찾을 수 있기를 바랍니다. 팬데믹이 가져온 불확실성은 적어도 분쟁 해결 제도의 발전에 있어서는 더 이상 장애물이 아닌 새로운 기회로 작용하고 있습니다. 사실 최근에는 중재와 같은 대체적 분쟁 해결 수단이 점차 장시간 고비용 절차로 변하면서 ADR 본래의 장점을 잃었다는 지적이 존재하였습니다. 이에 실무 관행의 개선과 신속 중재 규칙과 같은 보완적 규범의 도입을 통해 문제를 극복하려는 움직임이 꾸준히 있어 왔습니다. 팬데믹으로 대면 절차가 불가능해지고 신속한 분쟁 해결에 대한 수요가 높아지자 이러한 노력들은 더욱 탄력을 얻었습니다. 많은 기관과 전문가들은 화상 심리 등 다양한 대안을 적극 시도하였고 그 결과 오히려 효율적이고 경제적인 절차 진행이 가능하다는 점을 확인하였습니다. 이로써 중재는 효율적이고 경제적인 절차로서 ADR 본연의 모습을 조금씩 되찾아가고 있습니다. 이제는 한 단계 더 나아가 이러한 성과가 일시적인 변화가 아닌 발전된 제도로 정착할 수 있도록 관심과 노력을 기울일 때입니다. 특히 소규모 기업, 지식 콘텐츠 기업 중심의 신산업 분야는 업계 변화의 속도가 매우 빠르고 그 영향력이 광범위하므로 신속하고 효율적인 분쟁 해결 메커니즘이 절실합니다. 보다 발전한 중재 절차와 새롭게 주목받고 있는 조정 절차, 그리고 이 둘의 결합 형태는 기존 산업의 회복과 신산업 분야의 성장에 큰 도움이 되리라 생각합니다. 우리 대한민국 법무부도 기업 활동에 있어서 대체적 분쟁 해결 수단이 갖는 중요성을 분명히 인식하고 있으며 관련 제도의 지속적인 발전을 위해 보다 주도적인 역할을 하려 합니다. 우선 이번 컨퍼런스에서 제시되는 다양한 의견들을 귀 기울여 듣고 앞으로의 정책에 참고하겠습니다. 또한 아시아 태평양 지역이 국제 중재의 허브로 도약하기 위한 각종 지원 역시 꾸준히 이어나갈 계획이므로 여기 계신 관련 기관 및 전문가들께서도 많은 관심을 갖고 힘을 보태주시기를 부탁드립니다. 오늘과 내일 양일간 열리는 이번 컨퍼런스가 분쟁 해결 제도의 발전을 위한 끊임없는 혁신의 여정을 함께 하고 계신 여러분들과 뜻깊은 논의와 즐거운 교류의 기회가 되었으면 합니다. 다시 한번 오늘 참석해 주신 국내의 기빈 여러분들을 진심으로 환영하며 모든 분들의 건강과 안전을 기원합니다. 감사합니다.
Thank you, Minister Park, for your meaningful support. Next, to welcome us all, I'm delighted to introduce Professor Hit-Tek Shin, our wonderful chairman of KCAB International. Please, Professor Shin.
Could you turn on my video? Thank you. Good morning, good afternoon, and good evening, everyone all around the world. It is my pleasure and honor to welcome all of you to the 10th Asia Pacific ADR Conference. On behalf of KCAB International and Seoul IDRC, I would like to express my sincere appreciation to the representatives of co-organizers, the Honorable Beom-gye Park, the Minister of Justice of the Republic of Korea, Anna Jubin-Brett, Secretary of United Nations Commission on International Trade Law, UNCITRAL, and Claudia Salomon, President of ICC International Court of Arbitration. We thank you and members of your team for the continuing support and commitment to the success of Asia Pacific ADR Conference during the past 10 years. I also express my sincere gratitude to our eminent speakers and moderators. We appreciate the time taken out of your busy schedule to share with us your experience and insight on contemporary issues of ADR and international arbitration. This year, due to the lingering concerns of COVID-19, we regret that we again hold the conference virtually. The theme of this year's conference is Innovating the Future of Dispute Resolution Beyond 2021. The journey continues. Through this conference, we would like to review how the international arbitration community has coped with the new normal caused by the pandemic during the past 2 years and explore future direction of the international arbitration practice. Since the outbreak of COVID-19, we have been experiencing great uncertainty in every aspect of our life. International arbitration community has been no exception. Some said it's crisis, whilst others view it as an opportunity. To capitalize this as an opportunity, we must look for ways to utilize the experience and know-how we collectively acquired out of necessity after the dust settles down, rather than simply going back to the routines of the past. Changes in our practices, and in particular, changes of the mindset of the arbitrators and practitioners, as well as arbitral institutions regarding virtual hearings in international arbitration, is a perfect example. With this in mind, we refer back to the title of this conference, Beyond 2021, the Journey Continues. The ADR conference this year will be held over 2 days with 2 sessions per day. In today's first session, immediately following my welcome remarks, the head of major arbitral institutions and the representative of UNCITRAL will come together under the moderator of Mr. Peter Lever to review pioneering changes explored by each of them to address challenges caused by the pandemic and discuss the pathway to the future. In the second session today, arbitration practitioners will address the issue of accessibility of international commercial arbitration and explore changes and proposals for better practices in international arbitration. The third session, starting tomorrow, will review efforts made by ICSID, UNCITRAL, Vienna International Arbitration Center in refining rules applicable to investor-state dispute. A representative of the Republic of Korea will share their efforts and experience from the state perspective. The final session will conclude with a discussion of rising industries in post-COVID-19 era and how to make arbitration more user-friendly in resolving disputes in these new industries. KCAB International hopes that this annual event is a forum to explore ideas to further refine and innovate international arbitration and ADR practice to keep the promise of arbitration and ADR as an efficient and cost-effective and thus preferred method of dispute resolution to the parties in dispute. KCAB International and Seoul IDRC are firmly committed to offer users of international arbitration an efficient, reliable, and affordable dispute resolution service and the state-of-the-art hearing facility in this beautiful, dynamic, and safe city of Seoul. Last but not the least, I would like to express my heartfelt gratitude to all of the participants. Let's keep our fingers crossed in the hope that we meet each other in person this time next year in Seoul. Thank you very much.
Thank you, Professor Shin, for your warm remarks. It is a great privilege to have the conference opened by our leading representatives. On that note, let us now begin our sessions for the 10th ADR conference. Our first session, titled Pioneering Changes in Times of Uncertainty, will see our speakers address the recent challenges faced by institutions and their innovations to address such challenges. This session will be moderated by Mr. Peter Lever, QC. Mr. Lever is a full-time international commercial arbitrator at One Ethics Court. He is a past chairman of the board of the London Court of International Arbitration, a member of the Chartered Institution of Arbitrators, and appointed to the Law Society's Accreditation Panel of Arbitrators. Mr. Lever will be accompanied by representatives of each arbitration institution. I very much look forward to this session and pass the screen on to Mr. Lever now.
Good morning, good afternoon, good evening, everyone, wherever you may be in the world. It's a great privilege for me to be chairing this session, but I'm not going to say very much because we haven't got very much time and we've got a lot to get through. And what we have done is try to divide up the various topics between the very experienced members of the panel. And I'm pleased to say that we had volunteers for every single topic. And the person who jumped in first was Jackie of the LCIA, the Director General of the LCIA, an institution with which I used to be associated. And Jackie is going to go first and speak in particular about the tension between the desire for efficient and effective proceedings, while at the same time safeguarding independence and impartiality. So over to you, Jackie, and we look forward to hearing what your ideas are.
Thank you very much, Peter. Thank you to the organizers of this event. It is a great shame that we are not able to meet in person, but the flip side of that is that we are able to meet and greet a lot of people who might otherwise not have been in the opportunity to attend. And it is a great pleasure to be here with my colleagues from a number of other institutions, because what I'd like to talk about is not so much an LCIA issue. It is an issue that affects practitioners in whichever setting they arbitrate, and I'd like to focus on the potential role for institutions wherever they are based who are facing with the challenges that Peter introduced. On the one hand, we want our arbitrations to be efficient and effective. We want knowledgeable, experienced, informed arbitrators. But at the same time, obviously, we want arbitrators to be completely independent and impartial. This is a topic that is dear to my heart. I spoke about it about a year ago in the Freshfields lecture in London. And I think it's a topic that I will be able to address until I retire, hopefully in many, many years from now. There's always new developments, and I was particularly grateful for Claudia for her institution providing some information just as I was about to go to bed last night on something I was going to address anyhow. It is a constantly moving feast. So what am I going to talk about? As I said, we want impartial, independent arbitrators, but knowledgeable arbitrators. And there is tension. This tension was addressed in the High Court case of Halliburton versus Chubb, which was not an institutional case. It was a case seated in London. And it was interesting and illustrative that a number of institutions, including the ICC and the LCIA, intervened in this non-institutional case because the topics are so relevant for our work. That case, I'm not going to go into the case specifics, involved related arbitrations between, to some extent, overlapping parties. In a commercial case, that's important to keep in mind, various disputes arising out of a related event, or one event that led to related disputes involving a number of parties, in this case in particular insurance companies. What I'd like to focus on now more specifically is parallel proceedings and concurrent arbitrations. All institutions united in this panel have rules that provide for the ability to consolidate cases. The precise mechanics may differ somewhat depending on which institutional rules we look at, but there are provisions which provide boundaries when it comes to combining cases formally through the tool of consolidation and make them, well, technically, potentially still multiple cases, but at least hear them as one united case. There are limits because party autonomy needs to be respected, and if parties have concluded slightly different clauses in distinct contracts, not with identical parties, then there are limits to what you can bring together via the tool of consolidation. Again, most institutions, and that includes those present on this panel, additionally provide for the ability to hear cases concurrently. And the question I'd like to ask my co-panelists and you is, how effective is this tool, also against the background of some recent cases we have seen? We've seen a number of recent challenges come to the surface, in particular involving a few investment arbitrations. And here I think we should be a little bit cautious, as ever, to extrapolate results or findings that pertain to investment cases to commercial cases. One of the reasons why many of these cases are public is because of the transparency rules that specifically apply to investment cases. So even numerically, I'm not suggesting that these cases are an indicator of the frequency of this issue surfacing. Also, because of these transparency interests, I'm not suggesting necessarily that the lessons learned from these cases can be extrapolated to all other, in particular, commercial cases, but still. We've seen a number of cases, many reported, at least to some extent, notably through GAR, and there have been a number of cases. July, there was a report of a PCA case and an ICSID case involving Stephen Dreimer, where there were, who was involved in two cases involving the same country, in that case, Venezuela, where the allegation was that the dual appointments might lead him to formulate views based on deliberations that his co-arbitrators were not party to. That led to his challenge and stepping down from the ICSID case. We've seen a case involving Jan Paulsen in two related ICSID cases, two overlapping ICSID cases. We've seen an ICC case involving Klaus Sachs, and I'm giving these names deliberately because these are very esteemed arbitrators and they're publicly, it's publicly available information, who was involved in an ICC and an ICSID case involving Georgia, where he was successfully challenged. The basis there was the fact that there was substantially the same factual background and that there would be a risk of overlap of legal issues. So there was a risk of unconscious bias. And yesterday we read that Kai Hober was challenged in two overlapping referrals, an ICC and an ICSID referral, which led to his successful challenge. I'd like to juxtapose that to a yet unpublished LCIA decision. The LCIA publishes challenge decisions, but we tend to do that after anonymization and taking into account a certain delay, because if cases continue, it may not be helpful to provide the publication too soon. But in that case, the challenge was not successful. In that case, it was a situation, a commercial case, where the same tribunal, or at least overlapping arbitrators, were involved in a series of related cases. But what was interesting in that case is that the parties deliberately staggered the decision-making in the various cases. And one of the reasons why the challenge was not upheld was that the court decided that if you willingly, deliberately agree to have one case go first, you can't subsequently complain that the findings in that case are a factor to be taken into consideration to evaluate the impartiality or independence of the arbitrator in the other cases. You could have just continued to hear them completely simultaneously, but that would have been very inefficient. So that was a decision that was taken by the participants in the various arbitrations. So that challenge was not successful. So in that case, I'm not suggesting it's the nature, the commercial nature of the case, but it was the procedural structure that led to a different outcome. What am I trying to say with all these examples? I think users are looking to institutions to provide guidance, to provide structure, and we're more than happy to do so, but that has to be supported by buy-in from the users. What do we want? It is relatively easy for an institution to police certain norms, but there has to be an acceptance of what works and what doesn't work. If a case comes to an institution and we see that there are two related cases where consolidation is technically not available, and there is then a request for concurrent arbitrations, what do users want from institutions? Do they want the same arbitrators for efficiency reasons, or do the parties have a right to different arbitrators? And that is a line of thinking that you could base on these examples I've been giving you, that it should sometimes not be preferable to have the same arbitrators hear those related cases. I think as institutions, we are not taking a position on this, but we need to be informed by what the users really want. So I'm not suggesting that I have a single solution, far from it. If anything, I'd like to hear from my colleagues how they deal with these cases, because it is something we're seeing more and more, where arbitrators are, for instance, the parties nominate the same arbitrators, and they then seek different chairs, either by direct appointment or by requesting the institution to appoint, which is inevitably going to lead to the kind of discussions we've seen give rise to these various cases I identified at a very high level. So I would like to end my comments, Peter, if I may, with a question to my colleagues. Educate me, how are you seeing this issue increasingly? And I should say this is against the background of a continuing very small number of challenges that the LCA is seeing. We're seeing on average about 6 a year. I don't know if that seems to be the magic number, no matter what the caseload is. Actually, proportionally, the number of challenges even decreases. So we're seeing a very small number of cases, but the proportion of challenges that go to this issue seems to be on the rise. And we have a provision about concurrent hearings in our rules, which the users seem to want, but I'm a little concerned that this may be causing more problems than it will provide solutions, but hopefully my colleagues can help me resolve these issues. Thank you very much, Peter.
Thank you very much indeed, Jackie. That was a very, very good start and thought-provoking. Now, Claudia, I'm afraid that you're in the firing line on this now, because you sent some information to Jackie last night, which she's incorporated into her remarks this morning. So
via GAR. I'm not blaming Claudia personally for sending this information. It came to I suppose many of us through GAR last night, but
that was the. Thank you. Yeah, thank you. Thank you so much, Jackie, for your excellent start to this panel, to Peter, and to certainly the organizers and hosts for this event. Just to clarify an important point about the way the ICC court addresses challenges and the publication of decisions with regard to challenges. So the information about this challenge was not sent to GAR by ICC, and it's not something that ICC publishes at this point. Under the ICC rules, the court will provide reasons to the parties with regard to certain decisions made by the ICC court, including decisions regarding challenges, if a party makes that request before the decision is made. And it doesn't require both parties seeking reasons, just one party. So the information about this decision with regard to the challenge would have come via one of the parties. And at some point, we will certainly have a compendium of decisions with regard to challenges, and we'll be able to publish those on an anonymized basis. And that really is part of our overarching efforts with regard to transparency, to provide more predictability to the parties regarding how the ICC court addresses these issues of challenges. I do think we are seeing more challenges raised in the context of concurrent proceedings, not necessarily before the same institution, but before more than one institution involving the same party. And we're likely seeing that type of challenge because there isn't necessarily the established norm in this context. In the same way that I think all of the institutions are seeing challenges in the context of cases involving arbitrators who have sat together repeatedly, differently than simply repeat appointments by the same party. So the ICC court, as evidenced by the decision that was made public yesterday, looks at all of the facts and circumstances with regard to these cases involving the same parties. And in essence, the issue boils down to whether there is a potential for the inequity of information. In other words, that one arbitrator on the tribunal is going to have different and perhaps a particular type of information regarding one of the parties, the facts and circumstances before the case, different than the other arbitrators as a result of the concurrent proceeding. So it wouldn't be simply a hard and fast rule that if there are two cases involving the same party, that necessarily forms the basis for a challenge. But it's really looking at the particular circumstances, the particular facts, the particular legal issues, and indeed, in the context as well of whether those matters were disclosed.
Peter, might I make a brief pointing comment? Claudia is right to stress the inequality of information. That is a theme that comes out of a lot of these decisions. But really, my question tries to go beyond that. And I should have been more explicit in my comments. I know these decisions, I know that is a consideration, but my point really is, are we convinced that that is the right approach? Because, and that's why I gave this example of parties deliberately structuring a case differently. If there are overlapping arbitrators, but not identical arbitrators, what would then prevail when you go into a case knowing that there are non-identical tribunals, but you agree on concurring arbitrations? Is inequality of information then as important as it is, at least in some cases? And I think we should probably not focus too much on the actual decisions, because they are definitely fact specific, but more in abstract, what do we think? What should prevail? Are we comfortable that inequality should always be a decisive consideration? I personally don't think it should be decisive. I also don't think that the problems are limited to inequality of information.
So just quickly, Jackie, in the example you provided where parties have agreed that they're going to have concurrent proceedings and maybe have the same party appointed arbitrators and different chairs, from that perspective, and that is a really different set of circumstances because the parties have agreed that that's how they're going to proceed. And so the concern with regard to inequality of information and the concern with regard to cases involving one arbitrator having information different than the other two is in the context in which there isn't such agreement, and in particular when there isn't disclosure.
Thank you very much, Claudia. Can I ask Sarah what the view is in Hong Kong about these problems?
Yeah, so I think these are these can be really tricky, but what all of the institutions do, I believe I can say correctly, is that you decide it on a case-by-case basis. So in our rules, we have the roadmaps and the parameters that apply to whether or not a contested, consolidated application will be granted. So we've set out the rules for the parties. And then the contact point for the institutions with respect to making these decisions is deciding whether or not to consolidate, and also deciding whether or not to confirm an arbitrator who has been so designated. And so those are different decisions, and they're taken against different tests. We've had a number of scenarios where we have had situations where there is one arbitrator who is appointed in a case, in two related cases, and would present a situation of asymmetric access to information. And the way that we've analyzed that is that where the parties are not identical, where the parties are not identical and where the tribunals are not identical, but that person has access to different information in different cases, and information may be relevant across the cases with respect to one party's case, then the other party is not ever going to be able to have the ability to present its case before that arbitrator. And that therefore goes to enforcement. Also, that arbitrator is going to be in a difficult position because of their confidentiality restraints. How can they share information that may be relevant from the other arbitration in the other arbitration? So in some situations like that, we have decided not to confirm. So we have also, in the context of deciding contested consolidation proceedings, decided frequently to consolidate over the objection of one side, where we saw, and based on our test, saw that the cases met the test and were appropriate for consolidation. Having said that, there are scenarios in which we have decided not to consolidate. Under our rules, the test for consolidation and for commencing one arbitration invoking multiple contracts is the same. And so what we see more and more nowadays is parties or claimants simply beginning proceedings in a consolidated way from the outset, rather than commencing separate arbitrations and then trying to consolidate, because it makes more sense. It's more efficient to do it from the beginning. We also have a separate proceeding, which is quite different, which is our concurrent proceeding. And Jackie, I don't know your rules off by heart in this regard, but for our concurrent proceedings, that's where we have identical tribunals, but the parties may be different, but there's a common question of fact or law. And that is a decision for the tribunal to take, whether or not they run those matters concurrently. And we put that in deliberately to our rules to cater for those cases that could not be technically consolidated. So we've got a few options in our rules, and really it's on a case-by-case basis, but I think always the lodestar for every institution has to be enforcement. You want to make sure that it's enforceable, so then perhaps that would mitigate towards a more conservative approach and really following the parties' agreement.
Thank you, Sarah. I think enforcement is really the key to all of this. And I'm not sure, listening to the three of you so far, and I'm going to ask Kevin and Jason in a moment for their views. It seems to me that there can be no hard and fast rules that are going to deal with these situations. They've got to be dealt with on a case-by-case basis. I can remember being involved in a series of pharmaceutical cases. There were 9 cases that were brought. I was appointed as chairman in 5 of them. Another fellow was appointed as chairman in 4 of them. There was one arbitrator who was appointed in all of them. And there was obviously going to be a problem, but we managed to resolve it with the cooperation of the parties and got through to just about the start of hearings. And lo and behold, the parties settled. But I think the only way you can deal with these things is by looking at them on a case-by-case basis and doing the best you can to make sure that there is as level a playing field as possible and equality of information. Kevin, what's the view in Singapore?
Thanks, Peter. Well, I would start by saying that all the institutions have come a very long way by introducing provisions for multiple contracts, consolidation, concurrent proceedings. I look at some historical artifacts from SIC's cases. You might say have a series of of 10 arbitrations, all providing for a 3-member tribunal, and then one party quite intentionally will nominate a different arbitrator in each one of those 10 arbitrations. This is before provisions on consolidation. And now you have a different tribunal with a different nominee, likely the respondent's nominee, in all 10 of those arbitrations. I would agree with Claudia that this issue now arises not so much for the nomination of the chair, it's more for a different co-arbitrator across the arbitration. So what do you do as an institution? I think as an institution, you want to encourage and have a regime of full and frank disclosure. So any arbitrator nominated in an SIC arbitration or an arbitration of any of these institutions, they are going to disclose if they're an arbitrator in another related arbitration, and trust the institution to deal with this appropriately. So we'll put the comments to the parties, get their views, and then as Sarah said, then you have to decide on the confirmation. So do you want to not confirm that arbitrator that may have access to different information than the other members of the panel? Or do you want to give effect to the party's right to nominate an arbitrator and perhaps deal with that at the challenge stage? I think the danger is when you have that inequality of information and there's not a challenge. A party may be reserving all the way, we don't get it dealt with by way of a challenge, and then it becomes potentially an issue at set aside or enforcement. I think that there's also tactical choices by the moving party in an arbitration. So if you're a claimant and you're the moving party on a suite of 5 or 10 contracts, do you want to take advantage of consolidation? So let's say that the cases are compatible. Most of the institutional rules will then provide for the nominations to spring from the date of consolidation. And then as Jackie said, this often raises more questions because if you do consolidate matters, and particularly if the rules don't provide for the identity of the parties, so you can have different parties, now you may be in a multi-party situation. So then a DUTCO multi-party appointment is going to be at play, which sometimes can be the cure. So if you get the consolidation in this 3-member tribunal, and now you have a multi-party situation, and there's perhaps asymmetric clauses across the contracts, now if you don't get a joint nomination on each side, you have the institution potentially appointing all 3 members. So it ultimately has to be horses for courses. It is an issue we're seeing more, and not just within SIC arbitrations. You could have concurrent proceedings at other institutions or an arbitration and a litigation, and it takes a great degree of precision from the institution.
The idea of not saying anything and letting the arbitration go on until you get to the enforcement stage seems to me to be taking arbitration back about 30 years when people would keep things up their sleeve until enforcement. I don't think that they would get away with that nowadays, so far as the courts are concerned. I think they would be required to make their applications as soon as they knew what the position was. But it'd be interesting to hear what Jae Sung's view is, and then what Sue's view is on these matters.
Thank you, Peter. I mean, as representing Untitled, our users are states, and Jackie had mentioned that users want to find the solutions to address concurrent proceedings and multiple proceedings. And from the state's perspective, these multiple proceedings in the ISDS context is a big problem for them because it costs them a lot of money and a lot of time. The issue that we have identified so far is that these multiple proceedings arise from a number of different factors. For example, it's multiple investors raising a claim against the same measure by the state. It could be based on different treaties. It could be difference in the different corporate structure, including by shareholders. So what we have identified is that there have been calls from states to address the multiple proceedings and concurrent proceedings in a more structural way, in a more broad sense. And that is why in the context of Working Group 3, which is developing reforms for ISDS, it's investor-state disputes, we are trying to find the solutions to this problem as a whole. Now, some of the solutions have been mentioned. Challenges by the arbitrators if they're the same. Disclosure or some cooperation mechanism between the tribunals was another. Coordinations or joinder is also being mentioned. And we're also discussing the possible ban of shareholder claims in the context of ISDS. So a number of different structural reforms to this multiple proceedings issue is being discussed at Untitled, but I will stop here because this is more in the ISDS context and not in the commercial context.
Thank you very much, Jason. Sue,
Yes.
What's the position, what's the view of Kcab on this?
Yes, so before I respond that, it's a pleasure to be in this panel, and it's very, very encouraging to see representatives from major institutions talking about the same issue in a very frank and helpful way to each other. For KCAB International, there are rules about concurrent proceedings in the rules, but I noticed that even if there are situations where there are related cases, parties tend not to use the rules as much. And even when going through the arbitration appointment proceeding, the KCAB Secretariat tends to be a bit conservative about allowing a constitution of tribunal on related cases that might create a asymmetry of information, or even a perception of asymmetry of information. I think we tend to be a little more sensitive to any reluctance or reservation by a party about having two slightly different sets of tribunal look into two different cases that have issues that are related to each other. Probably, or perhaps because overall the KCAB proceedings tend to be a little shorter and a little more efficient than the other arbitrations in other jurisdictions. It hasn't been raised as a major inefficiency issue that we see as an immediate challenge. It was very interesting to hear what the other institutions have experienced, and we'll probably look into that in the future if we have similar issues as well. Thank you.
Thank you very much. We have a question from Herman Knott of Kunz Lawyers in Cologne in Germany. Are the issues we're discussing here not also relevant with respect to conflict of interest of arbitrators as underlying the Halliburton case decided by the Supreme Court? Well, I think that they are all related topics, and I think that may be a very convenient moment for me to ask Claudia to talk to us a bit about how you engage the parties further in the arbitration process, so that these problems can get ironed out at the earliest possible moment, get resolved at the earliest possible moment, because there seems to be a consensus that you're going to have to deal with all of these issues on a case-by-case basis and not by institutional rules, other than the rules which relate to disclosure.
Thank you. I was interested in hearing Professor Shin's comments when he talked about changing the mindset of arbitrators and institutions in the context of our working in a virtual environment. And what I have really focused on since the start of my term as of July 1st is indeed a focus on international arbitration with a client mindset, that the arbitrators and the institutions are focused on thinking about the parties as clients for purposes of trying to focus on what indeed the parties want. Of course, outside counsel have clients in an arbitration, but in essence, the parties are our clients too, again, just for purposes of this mindset. So I believe that if we focus on engaging the parties more in the arbitration process, enabling their engagement, there is going to be better alignment between what the parties seek in an arbitration and the arbitration process itself. Because we know that when parties are in an arbitration, they don't really want to be in an arbitration. What they really want is a resolution of their dispute, and the engagement of the parties in the process better reflects the role, the changing role of in-house counsel now as real advisors to the C-suite and assessors of risk. So just quickly, some of the ways in which I believe that arbitrators and institutions can more effectively engage the parties is in the first instance asking the parties themselves whether they wish to be copied directly on communications from the institution and the arbitrators, so they have the information in real time. Secondly, we've certainly talked for a very long time about the parties' representatives or in-house counsel participating in the case management conference or first preliminary hearing. But I think it's time to really focus on that more with concerted effort, and so that the tribunals are really expressly stating to the parties whether they wish to have a representative attend. And now that in almost all instances, these first preliminary hearings or case management conferences are held virtually, it really does enable their participation. I know from my own experience as arbitrator recently, during a preliminary hearing, there was a dispute about the date of, when the evidentiary hearing would take place. And it seems like a small matter, but just in the context of the preliminary hearing, I was able to ask everyone to just go on mute because we were in a setting very much like this. And outside counsel could speak to their clients in real time, find out what really mattered to them with regard to the timing and what really was the situation with regard to their availability. And that issue was resolved right then and there. It just eliminated the subsequent communications, emails, follow-up as to what really was going to be the date. A small matter, but something that really drives efficiency. And then thirdly, I think we really need to focus, and this can be the topic of a much larger conversation, but really focusing on the procedural timetable as something that's not locked in stone. But of course, there's a desire to get a hearing date set so that the case doesn't have delay as a result of availability. But so frequently, the parties have a better understanding of the case, a better understanding of the issues in dispute, a better understanding of what their real positions are going to be and possibilities of settlement after a first round or a second round, additional round of submissions. And it may be an opportunity for a pause so that there can be closer integration between an arbitration and other means of resolving a dispute like mediation or other methodologies or other ways of thinking about the procedure.
Thanks, Claudia. I think that the point you make about trying to get involvement of the parties at the case management conference, the first case management conference, is very important. Speaking for myself, my practice has been for many years now to, when I write to the parties to try to arrange that first case management conference, to say to them it would be very helpful to the tribunal if a representative of the party could be present. Because if you do have a representative of the party present, then there is a greater buy-in to the procedure that is agreed at that case management conference, and probably in particular to the timetable. It's much more difficult for a party to complain that they haven't been involved if they've been present at a conference where a timetable has been agreed between the parties and where the procedure has been agreed between the parties. And I remember one instance where there was a dispute about whether a case should be heard on such and such a date or on another date. And I said, right, well, what we're going to do is we're going to rise, we're going to have a cup of coffee now, and we'll come back in 15 minutes, and you can have a chat amongst yourselves, sort it out. And they did. And that's the way I think it can work, but it does require, I think, much greater involvement by the general counsel or the senior executives of one of the parties, so that you can get to that sort of result. I wonder if any of the other members of the panel have got any views on what Claudia has said. No one?
Peter, just very quickly, I really like the language of client mindset. And I think that that's what we're trying to do as institutions. And I would add being commercial. This is ultimately what we're trying to do. We want to meet the expectations of the parties. I think what parties don't like in arbitrations is where they get surprised. So with all the institutions here, whether it's communication of reasons, keeping the parties updated, or keeping them involved in the process, one thing that we've seen quite often, the default under the SIC rules is that the institution appoints the presiding arbitrator. Parties increasingly are adopting the appointment procedure from Untitled, where they want a list procedure or a strike and rank, because they want to be involved in that very important process of appointing the presiding arbitrator.
Well, I think that's certainly right. But I also remember being at an IBA conference in Stockholm a few years ago, where general counsel of a very, very major international company said the day that I am not able to appoint my own arbitrator will be the day that I stop using arbitration and go over to litigation. So, I mean, I think that there is a balance to be struck here. Jackie, you look as if you're...
Yeah, might I pick up the point of balance based on Claudia's very interesting comments? I think we need to strike a balance between being inclusive and involving the real parties, the decision makers. But I think we also need to be a little bit careful when it comes to who the spokespersons are, because, and I'm speaking from experience in a case or cases where you have multiple representatives of different levels. So you will have the lawyers, whether they're solicitors, barristers, or otherwise. You have the party representatives. You could even have the funders. We had an interesting example, an interesting case where a funder who was known to be involved in the case, so that was not the issue, started writing directly to the tribunal, to the institution. So what do? You've got counsel on record, you've got a party representative, maybe they were also copied in. As an institution, I think there's a lot, and as tribunal even more so, I'd say, there's a lot to be said for knowing who's holding the pen, who is the authorized representative. So I'm all for communicating, but implementing that in a safe and sound way may be a bit more difficult than people would like it to be.
Well, I think funders takes one into a different world, a different set of considerations. But I think that if you're talking about ordinary commercial entities, commercial companies, if you ask for and get general counsel of that company, you should be on pretty safe ground.
And you think so, but if you get different procedure, I'm not talking about funders talking about funding arrangements, but if you get, and that is not uncommon, unfortunately, if you have different layers of representation, and it could be solicitors and barristers or counsel in different jurisdictions, not speaking from the same hymn sheet can be a complication. Obviously, you would imagine that the general counsel is the highest, but at the same time, they've instructed external counsel as well. So I'm just saying that this is a very interesting and worthy approach, but will require some deft handling.
I mean, if
and I'll just jump in quickly, Peter, to say that I believe that engaging in-house counsel in the process wouldn't be, and I'm not in any way suggesting that the general counsel or head of litigation would suddenly become the spokesperson for the party in the arbitration. Indeed, outside counsel has that role, and there wouldn't be any risk, in my view, of in-house counsel or other business representatives suddenly being asked to speak when indeed they have outside counsel, because the outside counsel is there for that particular reason. But it really allows the outside counsel to consult with in-house counsel and the business representatives in real time and allow their concerns, especially about timing, to be addressed. We know, for example, that when a company has public disclosure obligations, timing about a stage in an arbitration or when an award is issued, 1 week versus a following week makes all the difference in potential stock prices and other implications for the company. It also impacts their internal reporting concerns. And so I believe that kind of those types of concerns can be addressed and heard by outside counsel as they're speaking on behalf of their client, and also, as Peter indicated, really assuring that there's buy-in so that in-house counsel and the parties can really see what's happening, and that then if they're agreeing to the process, there isn't some sort of surprise or misunderstanding about the process later.
I really do think it's that those two words, it's the buy-in by the parties that is the most important aspect of getting their general counsel or senior executives involved. I think it makes it much easier for the tribunal and much more difficult for the parties once they've bought in to resolve from the buy-in. I mean, obviously there are going to be changes in circumstances. A tribunal will have to take those changes into account, but there has been at least an initial buy-in, and that I think is very helpful. But I think we're going to have to move on because we're going to run out of time otherwise. And I would like, if I can, to ask Kevin to spend a few minutes talking to us about expedited procedure and early dismissal, and then I'm going to ask Sarah to chip in on that, and also Jason and Sue Hyun. So Kevin, would you like to have a go?
Yeah, what institutions really are doing every time we update our rules and procedures is trying to go back to the fundamental tenets of arbitration, and efficiency, speed, and cost effectiveness is one of those important factors. You see it in the Queen Mary White & Case survey, and all institutions have introduced some type of fast-track procedure. We're enormously pleased now that Untitled also has expedited rules, because that really gives the global blessing on this procedure. LCIA with their expedited constitution of the tribunal, how do we do it quicker? And for our part, we introduced our procedure in 2010. It's developed. We've gotten a lot of benefit from being able to look at the other institutions. How are they doing it? And I see it as really three constructions that are all represented here today. So in Untitled, it's going to require the express agreement of the parties. So that makes very clear that the parties have agreed to this. They decide at the time of the transaction that we want this fast track procedure. Institutions, HKIC, SIC, KCAB, we've got this expedited procedure in the main body of our rules, and we deal with it a bit different on the 3-member versus sole arbitrator. So HKIC will invite the parties to agree to a sole arbitrator. KCAB will encourage parties, and SIC, following the jurisprudence in Singapore, will appoint a sole arbitrator potentially, even if the arbitration agreement contains contrary terms. So looking at the cases of AQZ and ARA in Singapore, BXS and BXT, and then also modulated by the decision in Noble Resources from the Shanghai Intermediate Court. And then you have ICC by automatic application, now USD 3 million from 1 January 2021, more of an automatic application, and also contains language similar to SIC of this ability to appoint a sole arbitrator, even if the arbitration agreement contains contrary terms. I was very heartened and excited to be part of Untitled Working Group 2 with looking at some of the issues with expedited arbitration. And one of those big issues is what happens if the case cannot be completed in 6 months? So do you just keep extending the arbitration? Because if the award isn't rendered after 6 months, there could be an argument that the arbitral procedure was not in accordance with the agreement of the parties. So is an institution bound to extend, even when using those words, exceptional circumstances? So Untitled has made a bit more clear that this is only going to go till 9 months. We're going to limit the potential duration of the extension, and then maybe we're going to have to withdraw the case from expedited procedure. Expedited procedure overall, to me, is now one of the foundations of institutional arbitration. For SIC, this has really established us as an institution. We've had almost 700 of these applications, and it's almost now not really that much different, that this is being used in a lot of circumstances and parties can agree to it. And I think that what we want to see as an institution, we have a cap of around USD 4.5 million based on the amount in dispute. But if there is a very simple case that turns on a discrete legal issue and it's $100 million dispute, that the parties can agree to have the expedited procedure apply. So I think it's been very successful for all the institutions, and it continues to get more and more refined.
Now, if Kevin, if the procedure hasn't brought a result in 6 or 9 months, as the case may be, so that the expedited procedure has collapsed, it hasn't worked, then the parties go back to scratch, do they?
Well, so I think with institutional arbitration, you have the supervision of the Secretariat. The challenge that we had in UNCITRAL Working Group 2 is most of these UNCITRAL arbitrations are going to be ad hoc. So you can never let it get to the place where it's 5 months and 29 days and the award is not in a position to be rendered. The institution needs to be following up much more quickly. And so if the tribunal needs to extend the time or make an application, they need to consult with the parties long ahead of being on the precipice of this 6-month timeline.
Yes, thanks very much. Sarah, what's the Hong Kong view on this?
So we have, well, it's one of our most popular provisions, and it's really useful for appropriate cases. Our cap is about $3.5 million US. So we have, as Kevin pointed out, and you have to, well, we will decide if it's a contested application. So it's not, we don't require the parties express agreement. And most of our cases are cases submitted under the monetary threshold. And very few cases actually are by party agreement. And it's for that reason that I will observe with a lot of interest how the UNCITRAL expedited proceedings are taken up. Because what we do see in our cases is that there's often a respondent will contest. But because we have our provisions provide for the rules that apply, then we can make the decision. In terms of the time limit, it's all of our cases, well, the average and the median number has come within the 6-month time limit, so it's working successfully. There are the odd occasions where the tribunal goes over the time limit. Usually that's because for just last minute issues, and we're able to extend the time limit. It's not a long delay, but what we do now much more is really remind the tribunal very early on the time limit, so that there's no way that can pass by their attention. So it's worked very well. It's very important as a process. It's not appropriate for every case. And there are cases where a claimant will request expedited proceedings and we will not grant it. For example, where we have situations where the case is perhaps based on allegations of fraud or misrepresentation, and there is going to have to be a hearing because, of course, the default is a documents-only process. And where we see that the process is not appropriate to be squeezed into 6 months, then we may not grant it. But again, as with all of the situations where institutions make a decision, we look at it very carefully on a case-by-case basis and make the most appropriate decision.
I tend to say to the parties, we can either do this on a Trabant basis or a Rolls-Royce basis. It's up to you to decide whether you want to do it on a Trabant basis or a Rolls-Royce basis. Unfortunately, I'm so old now that not many people know what a Trabant is anymore. So I'm going to have to think of a new car to castigate. Jackie, what's the position as far as the LCIA is concerned?
Well, the LCA is a little bit different, as I think all of you on the panel certainly know, and Kevin referred to our expedited appointment procedure, which is something we've had for some time. We don't have the kind of procedure you've been talking about with fixed time limits for certain cases identified by a financial threshold. That's been very much the view of the drafters of the rules, the users, that with the median duration generally and the ability of tribunals under the previous and current rules to use other methods to expedite, there was not real appetite for these provisions. And of course, Yesung's and Kevin's discussion of the risk. What if you have a hard and fast deadline and you then don't meet the threshold? What then is a factor, but was not even the main factor. I think the main factor is that where you've got arbitrators, whether they use car analogies or otherwise, who have the presence to take robust procedural steps, you don't necessarily need those provisions. So we have under the 2020 rules more explicit provisions to expedite, but not this type of standard expedited procedure as some other institutions have.
So your position is that really you depend upon the tribunal to get a move on with it if it is urgent, if it's important.
Yes, parties and tribunal. Parties are extremely important. Parties are the driver, because you will see a party when they request and file a request for arbitration, when they submit their answer, and in their submissions before the tribunal, making their case as to the nature of the case. I should also say that the fact that LCA cases are or in LCA cases, arbitrators are not remunerated on a monetary basis is a factor to be considered, because for us it's much less material what the and for the parties therefore as well, it's not as material to identify at the outset what the monetary interest is. This is a factor which will be taken into consideration to analyze whether it is a significant case that will, for instance, justify a 1 or 3 member tribunal, but the monetary value as stated by the claimant isn't as significant as it might be under other institutions.
Yeah, because the LCIA is paying on an hourly basis and not on an ad valorem basis.
Right.
What's the Kcab position, Sue?
Yes, so I think Kevin mentioned correctly that the KCAB tries to encourage parties to agree to follow the expedited procedure rules if it is of a certain size. But also in the rules, there is a separate chapter on expedited procedures, and there is a monetary threshold. And if it is under that monetary threshold, it's an automatic application of the expedited rules. The core of the expedited rules is that the award needs to come out within 6 months of the constitution of the tribunal. Of course, there's always a question of what happens if the 6 months is not observed. Is it like a drop dead type of situation? And I think we have sometimes situations like the one that Sarah just explained at HKIC, where there are just some last minute issues that need to be attended to. And therefore there might be a short extension, but not too much. But at the end, I think it really depends on enforcement issues. Does the fact that the parties or the award, the fact that the award came after the 6 months in contravention of the rules create enforcement issues? I think that's something that really depends on where the enforcement is being prosecuted and what the courts of that jurisdiction consider these rules to be. So I think that's the short of it. Thanks.
Very much indeed. Jason, are you pleased with what you were hearing about expedited?
Yes, I'm pleased that Kevin, Sarah, and Sue also mentioned that UNCITRAL has adopted the expedited rules. It is an add-on to the UNCITRAL arbitration rules, the body of it, which came into effect in September. So it's quite a new development. It's because the member states of the United Nations recognize the value of expedited arbitration as a streamlined and effective process. And I think Jackie mentioned it, but there was a big debate between how to ensure efficiency of the proceedings as well as the flexibility inherent in the arbitrations. And we had to balance that and also to balance the due process requirements that provided within the Institutional Arbitration rules. Now, some of the institutions you have already mentioned have expedited rules, but I think by promulgating the expedited rules by the as a UN text, we're hoping that it leads to more adoptions, particularly in jurisdictions which do not have are not so developed in arbitration. So it's more of a global blessing, as Kevin mentioned. Now, in preparing the expedited rules, there was a lot of emphasis on consultations and case management conference, as Claudia had mentioned. There was also a need for procedural timetables, and all of that is included in the expedited rules. Now, one additional aspect that was highlighted in the expedited rules was the increased use of technology, and we had to emphasize the discretionary power of the tribunals to use technology to conduct the proceedings, communicating with the parties, holding hearings, and holding consultations. So I think that is one aspect that we included in the expedited rules as a new aspect. Now, we had already, as one of the questions being posed in this panel is challenges faced by institutions. One challenge that we have is that UNCITRAL rules have to be applied universally all over the world, and therefore the states could not agree on a threshold amount when the expedited rules would apply, because that would differ really depending on the jurisdictions. And that's why the application of the expedited rules requires the consent of the parties, and there is no other threshold amount to have the rules apply. Now, another challenge, as Kevin had mentioned, is from the fact that UNCITRAL is not an administering institution. It is a norm-making institution of the United Nations, and therefore, we don't have the administering authority to further expedite the process or to make any decisions in this regard. And that is why the last article of the expedited rules, which has a 6-month time frame for rendering the award, was a big debate on how to address the consequences when this deadline was not met. We have to also safeguard against systematic extensions and also address the consequences of the award not being rendered within the time frame and the consequences of the award being rendered after, which poses the challenge issue. So I think that is where we are with the expedited rules. I'm not sure if you wanted me to go on with the early dismissal discussions, but I would stop there for the expedited arbitrations context.
Thank you very much, Jason. We haven't got a lot of time left, but there is another topic that I would like to just get the views of the panel on, and that is a topic that does interest the parties. And that is the early dismissal of cases, the early consideration, the early dismissal of cases. Speaking for myself, I've never thought that there was much difficulty in any of the sets of rules in a tribunal looking at a case and deciding that it couldn't succeed. I think there is a great hesitation amongst tribunals to take that course, but I would be very interested to hear what the views of the panelists is about early dismissal. Claudia, can we start with you?
Certainly. Well, when we talk about early dismissal, there's in essence a variety of types of dismissal, and one, of course, is the threshold question and the threshold analysis by the ICC as to whether the case meets the requirements on a prima facie basis. And so, we're looking at those issues, whether a case can proceed. Then, of course, there's the issues in the context of the determination by the tribunal itself. And I do think the term early dismissal gets used to sometimes talk about sometimes gets thrown about or bantered about as if the tribunal is not to do its job of assessing the case on, the facts and the law. But certainly in the context of threshold questions of contract interpretation or legal issues that can be determined without an analysis of the facts, then the ICC has specifically encouraged tribunals and parties to consider this when it issued its guidance note at the beginning of the pandemic as an effective method for case management.
Thank you, Claudia. I mean, it's important what you say about pure issues of law. The trouble is when those issues of law get mixed up with the facts, that makes it all much more difficult. What's the position with you, Sarah, with Hong Kong?
Yeah, so we in 2018 revised our rules and we included an early dismissal process. And in some ways, I think that this is similar to perhaps the process that Jackie was talking about with respect to LCIA and the expedited proceedings. We really looked at it because, you know, you don't really need this process in the rules. The tribunal has the power to decide a discrete issue in a case in an early process. And so we debated this quite a bit. And in the end, we decided to include a process in our rules. And so under our rules, a party can apply for an early dismissal process where they believe that there is a point of fact or law that is manifestly without merit, or there is a point of jurisdiction that is manifestly without merit, or even if the party putting the point of fact or law won on that point of fact or law, they would still not prevail in an award. And so an application can be made to a tribunal. The tribunal would then decide within 30 days whether or not it proceeds with the application. And if it does, then has 60 days to decide on the point. And of course, there's merit in that because if it is a dispositive issue, it can save a lot of time and costs. So we put that in because we received feedback from the financial banking industry that was something important to them. So that tool has been included. We have seen it used a bit, not a lot, but I think what's important is it's there, it's available, and I think it can also be important for less sophisticated enforcing courts to see in black and white a process included in the rules that the parties have signed up to.
Thank you very much. And does anyone else want to say anything? Because I do want to go on to one last topic before we run out of time, and that is the value added by institutions. Does anyone want to say anything else about early dismissal, early determination, or those topics that we've been discussing for the last few minutes? Jackie, I see.
Very briefly, as Sarah said, having an explicit provision was seen by some to be useful to nudge tribunals to indeed provide support in case of enforcement issues. We have seen a bit of an uptake, which I had personally not necessarily expected, uptake in requesting early dismissal, not necessarily obtaining it. And I think an area which is not without complications is the standards, because there is quite a debate about, you know, the institutions all provide fairly similar, contain fairly similar provisions in their rules, but then do you look at the substantive law to provide further guidance? Do you look at the law of deceit? So I don't think we're quite there yet in terms of how far this gets you, but it is interesting to see that some people may have been encouraged by explicit introduction into the rules, and if so, then that's, I suppose, a good thing.
Well, I think that it can get muddled up with the issue of whether you order a preliminary issue to be tried. I think that raises many more difficult issues than simply early dismissal on a point of law, as Claudia was talking about. But we are going to run out of time, but I would love to hear Sarah a few minutes on the value added by institutions.
I think I would say all of the above. I mean, the main products that we as institutions provide to parties are rules that have procedures within them to which the parties can avail, and tribunals can avail themselves to make sure that their process moves forward smoothly and can't be blocked. And then, of course, our case administration, you know, we are all staffed with highly experienced expertise staff. That's really important. And also our decision-making bodies. We have at HKIC, we have standing committees that have certain mandates, and they're made up of active practitioners, arbitrators. Importantly, I think linking back to our discussion on users, we also have an in-house counsel who makes decisions, and I brings to mind a case, a challenge case that we had, which was really a borderline case. And, you know, reasonable minds can differ all the time in arbitration. And we had this borderline challenge, and the in-house counsel came down on one side of the challenge to uphold the challenge. And that was really valuable because it was coming straight from a user. Case administration, decision-making, and appointments, of course, is one of the most important functions that we offer. And then I think I just want to mention briefly, because I think we as institutional people do this all the time. We work quite a lot in the sphere as the soft power that institutions bring. So for example, if you have a situation where a tribunal is perhaps charging fees inappropriately, this, you know, I'm talking about rare situations when an institutional person can get on the phone and you can really change that. And also there's quite a bit of bartering that happens at HKIC and perhaps also at LCA, because we work on hourly rate basis. Most often we can really work with arbitrators to bring their rates down to be commensurate with the case where that's required. And then I think also around delay, there's a lot of influence that an institution can do behind the scenes in terms of making sure that arbitrators, if they are delayed, that they speed up. And I think arbitrators really do listen to institutions. So that's also, you know, that's more behind the scenes work that we do, but I think is very important.
Thank you very much, Sarah. I think you've, I've seen a lot of nodding heads, which I think I'm going to take as being agreement. But what I would like now to do, just in the last 3 or 4 minutes that we have, is just to go round all of our very experienced panelists and say, right, we've discussed a lot of the problems. Where do we go from here? Who wants to start on that? Sue.
Yes, thank you. So it was really interesting hearing everybody and how each of the institutions are facing these challenges. I think one of the solutions is, which is always mentioned, is a better or more use of technology in international arbitration. Just a year and a half ago, when the COVID-19 pandemic started to take hold of everything, there was a danger that many of these hearings would have to be suspended for a long time, had it not been for those many virtual hearings and the technology that makes those things possible. And circling back to what Sarah said about soft powers of the institutions, I think institutions are positioned to provide the necessary nudge to the general users of international dispute resolution to go a certain direction by assisting or facilitating the process. And an example, I'd like to mention the SOL protocol on video conferencing. Curiously, it was not made after the pandemic. It was actually first drafted and discussed back in 2018, actually during an ADR conference, just like this one. It was, looking back, it was quite prescient that this activity would be going on. And that was because even back then, a lot of Korean companies in their hearings were using video conferencing. I think they were less daunted or reluctant about using technology. And also witness conferencing was something that most Korean company personnel didn't want to do. So a lot of them tried to, or there was a lot of occasions where people tried to use video conferencing as opposed to actually being on the hearing. Apparently, sometimes it pays off to do things that people don't usually do, because after that protocol had been drafted, a year and a half later, the pandemic started and people started asking us and reaching out to us, do you have a list of something that will help us with virtual hearings? And that prompted us to revise it, to publish it. And since then, there was quite a lot of uptake on it, and hopefully it has assisted parties in expediting or making their process more efficient when planning for the logistics. So that's a little bit of a solution, perhaps an indirect solution to many of the problems of delay and costs that we see these days in international arbitration.
Well, Sue, can I just say something as a user? I find Zooming incredibly tiring. If you're doing it for more than about 4 hours a day, you are absolutely wiped out. That is not the situation where you have an in-person hearing, where you can sit for much longer hours. I think you miss an enormous amount if you're conducting hearings by Zoom. You miss the immediacy of seeing the reactions of the parties and their counsel to various issues that arise during the course of a case. So I think it has a place. I think Zoom CMCs are here to stay and will probably be the norm, become the norm. But I would hate to see us lose the in-person hearing, largely because I don't want to be getting up at 4 o'clock every morning to conduct a hearing in Seoul or Hong Kong or Singapore, where it's mid-afternoon, and I don't really want my co-arbitrators in Hong Kong, Singapore, or Seoul to have to go to bed at midnight or 1 o'clock in the morning, because that's the only way you can arrange these things. And that doesn't seem to me to be a very efficient way of dealing with matters. It has its place, and I think, as I say, that it's very, very effective for CMCs, but I'm much less persuaded that it's really the way ahead for substantive hearings. I don't know whether what I have said is be too much of a rock into a very, very smooth pool, but Claudia, what's your, having only recently stopped being a full-time practitioner?
I think as we emerge out of this pandemic, we have a wonderful opportunity to assess how we're going to work, because we're not going to go back to the way things were. We have to take the best learnings from this experience, not only in the context of utilizing technology when we consider it to be appropriate, but thinking about the ways in which the international arbitration community can better reflect the global business community, and how our values can indeed reflect the values of the global business community. So it is our opportunity to have an international arbitration that is indeed not only more diverse, but more inclusive, as we think about diversity broadly defined, including gender, geographic diversity, race and ethnic diversity, and inclusive of people with disabilities.
Thank you very much. Sarah.
Peter, I've forgotten what the question was.
It's all about where do we go from here?
You know, all I can think of is my high school slogan, which was Semper Sursum, onwards and upwards. You know, what we spend our time doing at institutions is thinking about how to make things better. There's so much intellectual capacity that goes into this. So we'll keep modifying what we offer and improving our services, improving the technology that we offer, trying to be more transparent, growing the pool of qualified candidates, and in doing so, making it more diverse. So I think, you know, we have a bright future. Things will only get better.
I agree with that entirely. Kevin.
I would second everything that Sarah, Claudia, and everyone has said. Institutions are really working hard to help resolve disputes. That's ultimately what we're doing. There's lots of challenges ahead. I think the work that's been done on green arbitrations, publication of the appointment of tribunals, publication of decisions on challenges, all the institutions are looking at what the other institutions are doing and figuring out a way for us to examine our own processes. When Sue mentioned the Seoul protocol, the timing of that was an enormous assistance for all of the institutions working through COVID-19, because you see that following the Seoul protocol, every institution has released their own guidance. So now there's a collective scholarship from the institutions on how to deal with this issue. And we're seeing that across many of the challenges and opportunities in arbitration today.
And it reminds me that I get asked frequently to go and speak at the Swiss arbitration annual conference. And there, Michael Schneider always used to collect the rule books from almost every arbitral institution around the world. And I used to sweep them off the table and have them sent back to me in London. And I've still got many of them up on the shelf here. there's almost no difference between any of the rules of any of the arbitral institutions. They're all aiming in the same direction. And I think what I get out of this morning's chat, if I can call it that, is that that's exactly what is going on and has been going on for some time, that the institutions are all working together towards the same end, which is to improve the service that they give to their customers, to the parties who arbitrate, the lawyers who conduct the arbitrations, and there are various means that they have at their disposal. All I can say is that I look forward to the next conference, and I hope that if I ever get invited, it'll be, again, that is, it'll be held in Seoul, because I do enjoy going to Seoul, and I need to refresh my palate on kimchi. I don't know whether there's anything else that I think we've now run out of time, because I see a notice from KCAB that about 15 minutes ago, we had 10 minutes left to wrap up the session. But Jason.
Yes, I think you wrapped up very well. I think UNCITRAL has a peculiar role to play because we're not an institution, as you say. We don't administer arbitrations, and we have this progress mandate to progressively harmonize international trade law by making new norms. We've seen the experience of the expedited rules and the early dismissals, and I think the recent developments in the use of technology has called on UNCITRAL to also come up with new standards, as Kevin and Sarah had referred to. And we'll be looking into, we've done that in 2006 when we had to update our model law and the New York Conventions on the writing requirements. And we are going to be looking into what new standards are to be developed in the future by UNCITRAL. And we'll be having a working group session on that. And just so that, with this in mind, UNCITRAL will be trying to develop new rules, new standards based on the practices of the arbitral institutions. I just wanted to mention that. Thank you.
Thank you very much indeed, Jason. And thank you all very, very much indeed for participating. I've learned a lot. I've enjoyed it very much. I hope that the participants in the conference have also found it interesting and enjoyable. And it's the usual situation where you overrun your time and they've only got about 5 minutes before the next session. But thank you all very much indeed. I think that Sally, that's probably as much time as you're going to allow me.
Thank you. Thank you all.
Thank you all for the wonderful discussion. Now, before we move on to session 2, we'll take a brief break. So please return back to us at 5:40 p.m. Korean Standard Time. We'll see you soon.